Hello everyone, welcome to the US Immigration News. In this video, we're looking at one of the most powerful legal moments of this year, the Supreme Court's upcoming immigration decision, expected between October and November 2025. This isn't just another court ruling. This could redefine how immigration power works in America. It could change how USCIS interprets the law, how the NVC processes your green card case, and even how future presidents, including a possible Trump administration, can control immigration rules. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. The final months of 2025 are shaping up to be some of the most defining in decades for U.S. immigration. The Supreme Court is preparing to release a landmark ruling that could completely reshape how immigration laws are written, interpreted, and enforced, from the halls of USCIS to the smallest consulate abroad. This case has been building up for months, quietly moving through arguments and legal briefs. But now, as the justices prepare to issue their final opinion, immigration attorneys, advocates, and millions of families are holding their breath. Because the outcome won't just affect policy, it will determine who gets to decide what the law means in the first place. At the center of this showdown is a doctrine that's been part of American law for more than 40 years. Chevron deference. You might not have heard the term, but it shaped almost everything about immigration processing. It gave agencies like USCIS and the Department of Homeland Security the power to interpret vague parts of the law, deciding what counts as good moral character, how long an immigrant can remain abroad without abandoning a green card, or which documents are acceptable at a visa interview. That authority is now on the line. The Supreme Court is expected to decide whether agencies should continue to have that freedom, or whether judges, not bureaucrats, should have the final say on how immigration law is applied. It might sound technical, but this ruling could determine the pace and fairness of everything, from asylum approvals to green card renewals, from family petitions to deportation defenses. If the court strikes down Chevron, it will mean that courts across the country can override USCIS's interpretations. That would trigger a wave of lawsuits, force judges to decide immigration questions directly, and potentially grind agency decision-making to a halt. That could create chaos. Imagine thousands of immigration cases being sent back to court because a judge decides USCIS misinterpreted a rule. Processing timelines would stretch even longer. Families waiting for years could see their cases reopened or frozen. And every new policy, whether from this administration or the next, could be challenged in court before it even takes effect. On the other hand, supporters of the change argue that this will bring accountability. They believe agencies like USCIS and the NVC have been given too much unchecked power, making up rules without proper approval from Congress. For immigrants, though, this is about more than process. It's about predictability, knowing that the rules you follow today will still apply tomorrow. This October, multiple immigrant rights organizations have been warning that if the court curtails agency authority, the immigration system could fracture. You might see one interpretation of a rule in Texas and a completely different one in California. Green card approvals could depend more on geography than on merit. That's why this moment feels so tense. Because it isn't just about policy, it's about power. The Trump campaign has already hinted that if he returns to the White House in 2025 or 2026, he plans to overhaul the immigration system again, using executive orders and agency actions to tighten entry, limit asylum, and expand deportation authority. But if the Supreme Court now restricts how agencies can interpret laws, even a future Trump administration could face new obstacles in executing those plans. In short, the decision could reshape not only the Biden administration's immigration policies, but also the next administration's ability to reverse them. We're now standing at a rare crossroad in history. If the court upholds Chevron deference, USCIS will retain its broad power to interpret immigration law. keeping most authority within the executive branch. That means the Biden administration's humanitarian parole programs, DACA protections, and family reunification initiatives will likely continue with fewer judicial barriers. But if Chevron falls, and many legal experts expect it will, the balance of power shifts dramatically. Judges, not agencies, will have the final word. That would mean more lawsuits, slower timelines, and potentially conflicting rulings across the country. Think about the ripple effect that would have on processing. USCIS officers might hesitate to issue approvals without knowing how a court might later view their interpretation. NVC consulates abroad might delay interviews for fear of new litigation risks. Even the visa bulletin could face uncertainty if courts start ruling differently on how quotas are interpreted. And for families caught in this system, that means more waiting, more anxiety, and more heartbreak. This decision is expected any week now, with legal analysts predicting a mid-November 2025 release. The timing is politically charged. The United States is entering another election cycle, and immigration remains one of the most polarizing issues on the national stage. Behind the legal language, what's really at stake is something much more human. It's the question of trust. Who do you trust to interpret the law? Elected leaders, appointed judges, or career officers within USCIS and the Department of Homeland Security? For many immigrants, agency consistency has been their only source of stability. Even when policies changed, the process, though slow, followed a rhythm. If that rhythm breaks, the system could descend into confusion. Consider the impact on humanitarian programs launched since 2021, like the parole pathways for Venezuelans, Cubans, Nicaraguans, and Haitians. If courts start questioning the legal authority behind those programs, tens of thousands could lose their status overnight. Employment-based immigrants might also see uncertainty rise. The EB categories from EB1 to EB5 all rely on USCIS interpretations of qualifying employment, investment, and labor certification standards. If those interpretations become subject to constant court disputes, predictability, the backbone of legal immigration, could collapse. And then there's deportation. The Department of Homeland Security currently exercises discretion in deciding who to prioritize for removal. If Chevron is overturned, even that discretion could be challenged, forcing courts to micromanage what has long been an executive power. Every part of immigration, from who gets detained to who gets approved, could change. So, what should you expect through October and November 2025? Expect political reactions. If the decision limits agency authority, you'll likely see the White House issue emergency guidance to USCIS and DHS to preserve continuity. Expect confusion at local field offices as officers await legal direction, and expect advocacy groups to flood the courts, challenging or defending new interpretations in real time. Processing timelines could temporarily spike again as agencies review pending applications to ensure they're legally compliant under the new interpretation framework. NVC interviews may be delayed as consular officers await confirmation of procedural updates from the State Department's legal team. In simple terms, brace for turbulence. For those already inside the U.S. on temporary visas or pending status, it's a time to stay alert. Follow your case closely and ensure your documents and filings are up to date. For those abroad waiting through the NVC or consulate systems, patience will be key as the dust settles. Regardless of how the ruling falls, it will mark a turning point in U.S. immigration history. The rules of authority, who interprets, who enforces, and who decides, will be redefined for the next generation. And when the court finally releases its decision, likely before Thanksgiving 2025, the impact will be immediate. The headlines will focus on politics. But for millions of families, workers, and students, the consequences will be deeply personal. This isn't just a case about administrative law, it's about the heartbeat of the immigration system, the delicate balance between power, trust, and hope. Because at the end of the day, immigration isn't about numbers or regulations. It's about people trying to build a life, raise families, and contribute to a nation that was built by immigrants in the first place. The Supreme Court's decision coming this fall will determine whether that system becomes clearer or even more uncertain. And as of now, all anyone can do is wait. But one thing's for sure, whatever happens, it will reshape how America defines immigration in 2025, and it will be remembered for decades to come. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the U.S. Immigration News channel. Thank you for watching, and we'll see you in the next video.